You don't make that change in one place. You have to track down every single account and update every single form. That means your bank accounts, your investment accounts, your retirement accounts, your life insurance policies. Each one has its own process, its own paperwork, and its own opportunity for something to be missed. And something will get missed. That's not a theoretical risk, it's something that happens all the time. When people hear the phrase avoid probate, the natural reaction is to start adding pay on death or transfer on death beneficiary designations to every account they own. And to be fair, beneficiary designations do have a place in a well coordinated estate plan. The problem is when those designations become the plan itself. At that point, what you have is not a strategy. It's a patchwork system that looks fine on the surface, but falls apart the moment anything even slightly complicated happens. It's the estate planning equivalent of trying to do all of your car repairs with duct tape. It might hold things together for a while, but it was never designed to handle real pressure. Before we get into the details, I want to make one thing very clear. If you take nothing else from this video, make sure you stick with me all the way to the end because the last point we're going to cover is, in my experience, the most important. It's also the one that causes the most damage when it's overlooked. Let's start with the first major problem with pay on death beneficiary designations. They do not follow the rules you set up in your will or your trust. They follow the rules of the financial institution. That distinction matters more than most people realize. If you have carefully structured your estate plan so that a beneficiary does not receive assets outright until a certain age, maybe 30, 40, or even later, that plan is completely ignored when a pay on death designation is used. Instead, the financial institution typically distributes the funds outright at age 18 or, in some cases, holds them until age 21, and then they distribute everything in full. We recently walked through a real example of how this plays out in the real world in a blog and video titled, I Challenged a Simple Estate Plan. In that situation, an 18-year-old inherited approximately $1.1 million outright because her grandmother used beneficiary designations that said, equally per stirpes, and never updated her will after her daughter passed away. The granddaughter ended up inheriting all of those accounts as a college freshman. Nothing about that outcome was intentional, but once those designations were in place, the financial institution simply followed its form. The will didn't matter, the intent didn't matter, the result? An 18-year-old receiving a life-changing amount of money outright with no structure, no protection, and no second chance to fix it. The second issue is that beneficiary designations are extremely limited in how much planning they can actually accomplish. Most forms allow you to name a primary beneficiary and, at best, a contingent beneficiary. That's not planning. That is a basic instruction. Real life does not operate on a single layer of contingencies. What happens if your primary beneficiary predeceases you? What happens if your contingent beneficiary also predeceases you? What if one of those beneficiaries is a minor? What if there are multiple beneficiaries and one of them has unique needs or circumstances? A properly drafted trust can address all of those scenarios and more. It can go multiple layers deep, account for changing circumstances, and provide clear instructions for what happens in each situation. A beneficiary designation form cannot do that. It is, by design, a simplified tool, and when you try to force it to handle complex situations, it simply breaks down. The third problem is one that most people don't think about until it's too late, and that is the administrative burden of making changes. If your entire estate plan is built around beneficiary designations and you decide to change how your assets are distributed, a lot of probate attorneys downplay probate because the less clients understand it, the easier it is for them to keep the system going by just doing a will. If that wasn't explained to you, drop a comment. And if this was helpful, please like and subscribe. You don't make that change in one place. You have to track down every single account and update every single form. That means your bank accounts, your investment accounts, your retirement accounts, your life insurance policies. Each one has its own process, its own paperwork, and its own opportunity for something to be missed. And something will get missed. That's not a theoretical risk, it's something that happens all the time. By contrast, when your plan is coordinated through a revocable living trust, or even when the trust is named as the beneficiary, you make the change once inside the trust. The rest of the system, it stays intact. You are not changing forms across multiple institutions, hoping everything lines up the way you intended. Now we come to the final point, and this is the one I strongly encourage you not to skip because this is where consequences can become truly devastating. If a beneficiary receives assets outright through a pay on death designation and that beneficiary is disabled or receiving need based benefits such as Medicaid, that inheritance can immediately disqualify them from those benefits. And at that point, the beneficiary is put in an impossible position. They either have to spend down the inheritance just to regain eligibility, which completely defeats the purpose of leaving them the money in the first place, or they have to go through the process of having a trust created through the court system after the fact. That court created trust comes with significant restrictions. The use of funds is limited. There are ongoing requirements to the court and reporting all of that information, often on an annual basis or even more frequently. The administration is costly, time consuming, and intrusive. In many ways, it becomes a form of living probate that follows the beneficiary for the rest of their life. And when the beneficiary passes away, whatever assets remain are typically used to reimburse the government rather than going to family members or other intended beneficiaries. The outcome is almost never what the person who created the plan intended. A properly drafted trust, on the other hand, can be structured from the beginning to preserve eligibility for benefits, provide for the beneficiary's needs, avoid court supervision, and ensure that any remaining assets go exactly where you wanted them to go. If you want to better understand how to plan for these situations and avoid the kind of outcomes we've just discussed, I strongly encourage you to register for the training at specialneedsplanningwebinar.com. That webinar is going to walk through exactly what a really good plan looks like and the disaster that can happen if you don't. At the end of the day, beneficiary designations are a tool. They're not a comprehensive strategy. When used in coordination with a properly designed estate plan, they can be effective. But when they are used as the primary method of distribution, they create risks that most people do not see until it is too late to fix them. If you want a clear step-by-step explanation of how to build an estate plan that actually works the way you intend, without relying on duct tape solutions to avoid probate, you can get started with my free course at freetrustcourse.com. Again, that's at freetrustcourse.com. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.